If you're a business owner here in the United States and the Corporate Transparency Act is giving you a bit of whiplash with all of the back and forth that's happening in the court systems these past few months, well, you're not alone. You see, you may recall that there's this thing called the Beneficial Ownership Information Reporting Requirement. It's a requirement under the newly enacted Corporate Transparency Act, which went into effect on January 1st, 2024. The purpose behind the government's motive for setting this in motion is really to combat something that they refer to as money laundering and financial crimes. That's typically why you would understand that this particular reporting requirement is really being enforced by an agency within the government called the Financial Crimes Enforcement Network, FinCEN. Now, what's interesting about this scenario is for the longest time, I have been saying that the foundational concepts of the Corporate Transparency Act are fundamentally, facially unconstitutional. I believe that this is a significant overreach on the part of the government, really reaching into our small businesses and our own privacy, mandating that we disclose to the government information that they already have access to. It's burdensome. It's again, just government overreach. And there are a couple notable cases that came out in 2024. The most notable that happened most recently was this court case that occurred in Texas. It was Texas Top Cop Shop versus Garland. And in that case, the federal government actually lost. The Texas District Court essentially ruled that the beneficial ownership information reporting requirement was unconstitutional, and that happened on December 3rd, 2024. But just a couple weeks later, on December 23rd, the United States Court of Appeals for the Fifth Circuit essentially took a look at the case and lifted the injunction. They essentially said that we're going to take a look at this, but we're going to allow the government for the time being to enforce the BOI reporting requirement. On December 26th, a merits panel under the same Court of Appeals for the Fifth Circuit, a different group of judges, got together and said, well, wait a minute, this case actually does have a lot of issues that are constitutional in nature and need to truly be reviewed in its entirety. Now, the government obviously didn't like that. Government has spent a lot of time, effort, and energy trying to put this rule into effect. They've established a lot of procedures and regulations around it. So they petitioned to the United States Supreme Court for an emergency review. And that has pretty much started. Right? But here's the thing. In order for the Supreme Court to truly take a look at a case that comes before it, because there's a lot of cases that are positioned for the court, and a lot of individuals and plaintiffs and even defendants would love for the court to take a look at it. And obviously the court can't do that. There's a lot of things that happen in our legal system each and every day, let alone in a given year. There's just too much that the Supreme Court, they just would not be able to jump into it entirely. So they had this process where they would make a decision whether or not to take a look at a case. And that process is called getting a writ of certiorari. It's the ability for the court to actually take a look at the case and review either a segment of the case or the entirety of the case, et cetera. So the federal government is petitioning for that. They're petitioning for a writ of certiorari so that the United States Supreme Court could dive in, because they're hoping, and they've specifically requested, that the United States Supreme Court make a decision by January 10th, 2025 on this issue. Meaning they're hoping that the court will allow for the injunction to be lifted so that they can once again enforce the BOI reporting requirement. Again, I know that there's a lot of stuff going on, so hopefully you can follow with me. But here's the issue, or the interesting thing, at least, with regard to this process. Getting a writ of certiorari, only one judge on the Supreme Court makes that decision, a single judge. You want to know who that judge is? Well, it's Justice Alito. And for those legal scholars out there, you may already know this, and for everyone else who does not, let me just fill you in. Justice Alito tends to be one of the more conservative justices on the panel, on the court. That particular bench is filled with a variety of different individuals with different perspectives, but Justice Alito tends to be the justice who essentially doesn't really like big government and overly government-regulated type of activities, right? He doesn't really enjoy heavy regulation from a federal government standpoint. So my particular position on this is that it is unlikely that the federal government is going to be ultra successful on this particular issue. Now, there's still a lot of moving parts here, and there's a lot of stuff that could happen. So if you are a business owner in the United States and you're interested in staying in touch and in tune with those things that could move the needle for you, you definitely want to be someone who's paying attention and staying in this ecosystem so I can continue to deliver information that matters. Until next time, bye for now.